Well, I appreciate not only all of the fantastic information that's put forth here, but the scope of the problem and the fact that in a bipartisan nature we recognize that this is a national problem, regardless of politics or party. I want to address an area that I've not heard addressed much. Senator Booker in his testimony yesterday had mentioned upwards of 97%, I believe, of all adjudication of justice is done by plea. And I don't know the accuracy of this, and I don't have the data, but it brings out a major point. A person receives a charge. He gets publicity. Consequently, his employer fires him over the publicity. Then they have an inability to make bail because they don't have work, and then they can't obtain the best counsel because they can't afford it. The counsel that they do obtain then, in a deal with the prosecutor, is suggested to make the plea or roll the dice with the jury on an exponentially higher outcome of sentence. Faced with this duress, what we potentially see, and I would argue actually see, is the locking up of innocent people. How do we address that? Because we've not seen or heard anything along that line, and I welcome input from anyone on that issue.
I'll volunteer very quickly that the promulgation of disproportionate penalties and some mandatory minimums that are so extreme that you have that very scenario you described is driving that, and yet if you were to make punishment more commensurate and not punish an individual for going to trial to test the evidence against them, I think you would have a system that is intrinsically more fair. And that's part of the reform that has to happen on the front end. But for those that are in that system, that are the 97% that did it, we better have immediate back-end reform right now, or else they will continue to serve those very long, disproportionate sentences.
Congressman, my colleague, Mr. Tallman, during his testimony talked about mens rea reform and the importance for adequate mens rea. I think that's also a part of this. There are a fair number of crimes, particularly regulatory crimes, but also statutory crimes, where in order to convict somebody, you do not have to prove that there was any knowledge or intent to violate the law, or even that somebody engaged in something that is intrinsically morally blameworthy. And the fact that federal prosecutors have that pressure and can say, look, I don't have to prove whether you knew about the law, intended to violate the law. I just have to prove that you did the act that resulted in the crime, even if it was a mistake or a complete accident. Therefore, you're facing a very heavy penalty unless you decide to plea bargain. That's also part of the answer to this.
Yeah, it's an excellent point that you make, that you ask about, and there is data showing people that stay in jail pre-trial before their trial end up with longer sentences and are more likely to go to prison. And so some states like Colorado and New Jersey have adopted bail reform measures to ensure that people who are low risk can get out pre-trial even if they can't afford a bail bond through pre-trial supervision and a personal bond. It's kind of like being on probation, so they're held accountable to make sure they appear, but just because they don't have resources doesn't mean they're not able to get out. And then also strengthening, of course, indigent counsel and ensuring that there's quality representation. We have a pilot program in Texas going on, kind of like school choice, where clients can choose their own counsel from a list of qualified attorneys.
I would just say somebody was prosecuted. The leader of this conspiracy that I was a part of was sentenced to 4 years, 4.5 years. And I came later in that. I had been cooperating for a couple of years. When the government came to me, they basically said, if you cooperate, implicate these people, you'll see what you'll get, which is no time. If you don't, the range I was looking at was 19 to 25 years of prison. And I had real law and order, salt of the earth people, friends who believed in my innocence as I did, which is why I went to trial, say, you just got to take the deal. You have to take it for your kids. I said, you don't think I'm guilty? They said, it doesn't matter. You can't do that. And you see that a lot. And I don't know how anyone who thinks that, that there aren't innocent people in jail don't believe that people take those deals. You see the statistics. When the Innocence Project exonerates people with DNA in these rape cases, half of those people pled guilty. So you know it happens, and it's a problem, and it's a problem because there's not enough discretion for judges to counterbalance. I was lucky that my offense did not carry a mandatory minimum. That would have been tougher. At least I knew I was going to have a judge who was going to hear the evidence. But it's more proof to why you need to have more balance in the system.
And thank you, Mr. Chairman. I yield back my time.